Hello, everyone, and welcome to today's webinar, Immigration Enforcement in the Workplace 2025. Today's webinar is being recorded, and you will receive a follow-up email within 24 to 48 hours with a link to view the recording and a copy of the slides. You will have the opportunity to submit text questions to today's presenters by typing your questions into the questions pane of the control panel. You must send in your questions at any time during the presentation. We will collect these at the end and address them at the end of the presentation. Today's presenter is Peter Guattari, partner at Whiteford. I will now turn it over to Peter.
Hi and welcome, everybody. You'll see me briefly before I dive into the presentation, but I wanted to welcome you to what is a very timely topic, and I'm sure that there are a lot of concerns and questions out there. I'm going to cover a number of different topics. One, just briefly touch on executive orders and give you current lay of the land, where we are with immigration enforcement activity. And then I'm going to talk about specific types of enforcement activities, which would include I-9 audits and worksite enforcement actions. And then I'm going to turn toward a Know Your Rights section that will focus on what will inevitably be questions from your employees and what resources you can provide to them and how you might be able to assist them and calm their concerns in the current situation, so that you know, you're aware of what's going on, the employees are aware of what's going on, and it will minimize disruption and anxiety within your team. So with that, I'm going to dive into the program. Now I'm going to disappear from view, and we'll go right into talking about immigration enforcement in the workplace in 2025. Okay. So first slide, please. Just as a general disclaimer up front to say, this is, although I'll be talking about legal topics, this is not the giving of legal advice. It's to provide general information only concerning varying aspects of immigration law, and immigration law in particular is highly fact specific, and you really need to understand those facts and have a discussion with counsel before taking any action with respect to any specific matter in immigration law. Next slide, please. So where are we now? Well, I always like to say past is prologue. What did we see happen previously, and what are we likely to see going forward? We already have some idea of what is going to be undertaken, but if we look at what happened under the prior Trump administration, we saw restrictions on entry to the U.S. for foreign nationals of various designated countries, the so-called Muslim ban, which was challenged in court a couple of times before it actually was watered down to the point where it was less effective than the original plan had been. And what we saw, which impacted employers specifically, was extreme vetting, which was the process of giving very close scrutiny to immigration applications, particularly abroad at U.S. consulates. And this greatly increased the case adjudication time at U.S. consulates, and caused problems with employers looking to get employees into the country for specific work to be done on a timely fashion. It also prevented a lot of folks being able to come to attend conferences, seminars, etc. So it had a real impact on processing times at the consulates abroad. We saw zero tolerance policy, which resulted in family separation, also something that was challenged in court. We saw attempts to cancel TPS designations, an attempt to terminate DACA, which is deferred admission for childhood arrivals, or deferred action for childhood arrivals, excuse me, which essentially gave a large number, I think approximately 4 million people, access to work authorization and the deferral of administrative action to remove them from the country. That process is still subject to court litigation, but the program itself is still active for those who enrolled. and a number of you probably have employees who qualified under that program. And then we saw also restrictions on asylum. We saw the increased use of mass immigration enforcement actions, which did not occur in the prior administration, nor did they take place during the Biden era, with mass immigration enforcement actions being focused more primarily on drug interdiction rather than worksite enforcement. And we saw an attempt to increase deportation of foreign nationals without lawful status in the U.S. And that has actually continued and increased during the Biden administration, with a significantly higher number being actually deported during that time frame. And we also saw case adjudication in the immigration service processing centers significantly delayed, also resulting in a delay of employers of being able to get employees to continue their employment. We saw this with issues with respect to extensions of employment authorization documents, or applications to extend non-immigrant status, and those extended delays could increase costs because employers in some circumstances would have to file for expedited processing, which costs upwards of $2,500 to $3,000. Next slide, please. So what changes are likely in the new administration? Well, much of what we saw before, although I think it'll be much more organized and effective, as they've had 4 years to plan how they can change their method of attack in order to avoid court scrutiny. One thing we know is certain: we're going to see increased immigration enforcement and the use of 287G program, which would govern the use of local police forces in activities to arrest and or detain unauthorized individuals in the United States. That is starting. And some of the arguments you see around sanctuary cities and the focus on sanctuary cities for some of the earlier enforcement activities, not necessarily at the workplace, have been as a result of the intent to eliminate these programs that do not allow, the so-called sanctuary programs, which do not allow participation of local police. We're certainly going to see an increase in I-9 audits. I do not think that they have geared up to do this yet. I haven't heard anything to that effect. However, I think most of their enforcement activity at this point is on initial deportation activity, and with specific focus on criminal aliens. And that has been a particular source of activity recently. And there have been collateral detainees, that is, individuals who have been sort of in the wrong place at the wrong time, or at the home where the criminal alien may be, and are scooped up in the raid. So much of what has been done currently is being highly localized. We have also seen legislation in Congress which will increase the use of mandatory detention for any foreign national charged or arrested with theft, burglary, or shoplifting. These are low-level crimes. Typically, someone would be released on bond, but they wouldn't be in these cases, and that would permit DHS to scoop up these folks. So you're going to see some tension between local law enforcement authorities and their ability to detain or release an individual. This will make it a requirement that they hold them. However, then there will be an issue as to whether these folks get into ICE detention and get into the deportation process. Because there are a lot of individuals at the lower end who have committed criminal offenses, but they're low-level misdemeanors, and they have not necessarily resulted in them being put into ICE detention. So that may be a change, and that could potentially impact your employees. We've seen the rescission of the sensitive locations policy. Now, what that is that was a memorandum, kind of informal operating procedure, and it was a memorandum issued in 2021, a new memo in 2021, which said that enforcement activities wouldn't be carried out at schools, healthcare facilities, places of worship, places where children gather, social services establishments, disaster emergency response, weddings, funerals, religious ceremonies, parades, etc. So, that was sort of a zone of comfort that individuals could be at church, at school, and not be subject to arrests. There has been a lot of chatter about concerns of ICE agents coming into schools. I have not seen any evidence of that. What we have seen is that there have been checkpoints set up around and outside these areas that appear to be enforcement activity. Okay. Now, in some cases, we found out that they are not actually ICE agents. They are people misrepresenting themselves as such. So even though the sensitive locations policy has been rescinded, there hasn't been any particular evidence of enforcement activity on these locations, but that could change very soon, particularly if you are an agency which provides some type of relief services to individuals. Even if you have no idea whether those individuals are undocumented or otherwise, they simply are people in the community who come to utilize your services. Okay. We're going to see new restrictions on immigration classifications. We've already seen the withdrawal of TPS for Nicaraguans. The impact on this is going to be your employment eligibility for staff. If you have staff members who have DACA work authorization, who have TPS designation that allows them to get an employment authorization document, those folks are going to become unauthorized when they can't renew, or the TPS is terminated, as it was with not Nicaragua, but Venezuela recently. And that could be as early as April for some of those folks who were in the Venezuela program. And extended processing of asylum claims can also impact work eligibility. They're authorized to get an EAD within a period of time after filing for asylum. However, they don't become effectively work authorized as a matter of their status until they're actually granted asylum. And also, as we're going to see, there's going to be extreme vetting, which again will result in delay of immigration application adjudications. Already, the Department of State issued a notification that they were imposing more restrictions on visa interview waivers, which had been a great relief in the past for employers who were having employees going home trying to come back in to the United States. They didn't have to go and get another interview if they've already gotten their visa. Now they're going to have to do it in most cases, and that's going to impose a delay because it's going to create backlogs in application processing times at the consulates. Next slide, please. So what have we seen in executive orders? Well, 3 in particular that deal with immigration as they might be relevant to an employer. There are a number of others. We see that, as I said, the last thing I spoke about, the extreme vetting, and they're calling it enhanced vetting here for visa applicants for those in the country. That, of course, that will begin a delay in the adjudication of applications. Particularly if you've got somebody who, let's say, wins the H-1B visa lottery, but may not necessarily have student work authorization that lets them to cover the gap in their employment, and they may be out of work for a period of time while their H-1B is adjudicated. And the only way to push it forward is to pay the fees for expedited processing. We have seen an executive order that expands the use of expedited removal, authorizing state and local law enforcement to investigate, apprehend, and detain aliens, revoke certain Biden-era enforcement policies and guidance, including enforcement priorities, and will require undocumented workers to register status pursuant to some procedure that presumably will be put together by the Department of Homeland Security. So again, you're not going to just be dealing with individuals from ICE. You may be dealing with local police, and you may be dealing with deputized agents from the Department of State. Next slide, please. So what else is out there that's of concern to us? Well, it helps to know the lay of the land as to potential civil and potential criminal immigration offenses. Okay? So what are civil offenses? Civil offenses are the kind that might get you a civil penalty or fine. These fines at times can be quite exorbitant, particularly given how they are calculated. You could have fines in excess of $100,000 to $150,000 easily for a small workforce with a number of immigration violations per I-9 form, even though you don't necessarily have any clear evidence of any undocumented workers in your workplace. So what is out there as potential fines? Knowingly hiring or having knowingly recruited an authorized alien for employment in the United States, or knowingly continue to employ an unauthorized alien in the United States. Failing to comply with I-9 form verification requirements, okay? Not having the form at all can be a significant penalty. Having a form with multiple errors can be a significant penalty. And I'll talk about that in a little bit when we get to I-9 forms. Committing or participating in document fraud for satisfying a requirement or benefit for the employment verification process. This could also be a criminal offense depending on the severity of it. Committing document abuse, that is requiring an employee to produce more documents than are otherwise required under the Immigration Reform and Control Act. This more commonly occurs with somebody requesting additional documents from somebody who's already work authorized because they're a refugee or an asylee, or say requiring evidence of work authorization from somebody from Puerto Rico, or requiring everybody produce a green card when they may not have it. So these things do come up, and if they are referred to the Homeland Security, they will, or to the Office of Special Counsel, they will result in penalties. Unlawful discrimination against an employment authorized individual in hiring, firing, or recruitment or referral for a fee. This also can result in penalties. I had somebody who refused to or demanded evidence of extension of employment authorization for a person granted asylum, and that person was work authorized and that was sufficient. I know that's not clear to every employer, but the end result of it was that we had to pay her back pay and reinstate her during that period of time between the discharge and the resolution of the complaint. Failing to notify DHS of a final non-confirmation of an employee's employment eligibility. For those of you who participate in E-Verify, you'll know what that is, because you have to get a confirmation of a person's employment eligibility in E-Verify. And or requiring an individual to post a bond or security to pay an amount to provide financial guarantee against potential liability. Also a big no-no in the realm of immigration compliance measures under ION. Next slide, please. So from the criminal standpoint, and some of these are important for what we'll be discussing later on as to how do you respond to enforcement activity. Engaging in a pattern or practice of hiring, recruiting, or referring for a fee unauthorized aliens. For example, let's take something out of real life. An individual who was hiring employees, and the employees that he had hired had sequential green cards, which is extremely strange, much like somebody having, two employees having sequential Social Security numbers. But in that case, the employees were telling the Department of Labor, because this came up in the context of the Department of Labor audit, they were telling the employee or the Department of Labor that the employer was advising them where they could go to get documents to authorize their employment. So that raised potential criminal violations that came about in the context of a DOL investigation. Ultimately, the individual employer hired criminal counsel to assist them in the matter. Harboring, smuggling, transporting, or inducing and encouraging an unauthorized alien to remain in the United States. Well, smuggling is probably not going to come up on your list. However, transporting, which is knowing or in reckless disregard of the fact that an alien has come to enter or remain in the United States, and transporting them for helping them or furthering such a violation of law, could be simply driving an unauthorized worker from one site to another, okay? Particularly if they get stopped by ICE, that would be going from one, potential construction project site to another. If you haven't properly complied with I-9 verification requirements, or you accepted documents that weren't appropriate, and you're transporting the individual in the current regime, it's hard to say whether or not you might find yourself charged with transporting. Harboring is concealing, harboring, or shielding from detection an alien in any place, including any building or means of transportation. So, this can come up, and we'll talk about it later in the context of a worksite enforcement action. And it's going to be very important that your employees be trained in understanding what actions they can engage in and what actions they cannot, particularly if ICE or deputized police forces come onto the work site and are looking to arrest or detain unauthorized individuals. Okay? Inducing or encouraging could be simply employer knew workers were not lawfully present, continued to employ them, and facilitated housing and helped them obtain public benefits. There was a case out of the Fifth Circuit about 6 years ago or so, which upheld a conviction in those circumstances. Although in that case, they had a house where everybody was living, and was actually helping them get public benefits while paying them under the table. So the facts were a little bit more severe than they sound, but nevertheless concerning, particularly when there is increased emphasis on enforcement, detaining and deporting individuals. And as I have in the last slide there, Border Czar Tom Homan has already indicated a hardline policy. And he said this on television, where he complained about the slow progress in detentions and deportations because individuals seem to, quote unquote, know their rights. And his view was that the dissemination of this information was somehow a violation of the law. And he was recently in a Twitter fight with Alexandria Ocasio-Cortez on this very issue, threatening her with some type of unstated legal action, even though she has emphasized the need to tell the community out there to know their rights, particularly with respect to any enforcement activity, because an informed citizenry, knowing what their rights are under the law, will be able to protect themselves better from people overstepping legal grounds. I want to emphasize here, and I'll come back to this as later on in the presentation, that interference with police officers or obstruction can also be potential offenses depending on the circumstances. And this is why we need to train our staff to understand what's permissible and what's not permissible within the scope of the law, what actions they can take and cannot take, in order to avoid being drawn into some type of criminal enforcement proceeding. Next slide, please. So we've already been told that I-9 audits and enforcement actions are going to increase. We are almost certain to start seeing mass worksite enforcement operations. They are more likely going to be at target industries. What that definition is might be subject to change, but those are largely going to be industries where there is likely to be a large number of foreign workers employed, whether or not they are unauthorized or not. That can include construction sites. It can include retail businesses. It can include restaurants, hotels, any number of different types of businesses, certainly landscaping, lawn services. These are the types of businesses that might initially see enforcement activity, but bear in mind that enforcement activity can come about from a random selection, okay? Or it can come about as a result of a tip. So these things, you never know where it's coming from. I had a very small, very unnoticeable employer who got targeted not long ago. They won't tell you what it was that kicked it off, but sometimes you can figure out from the circumstances. Again, the sensitive locations policy, this is not going to protect you from audits or enforcement actions, and it was recently revoked. And I mentioned earlier about deputizing local police forces. Yesterday, I read that the Department of Homeland Security has deputized or plans to deputize up to 600 Department of State employees as immigration agents. They realize they are woefully understaffed for the kind of activity that they want to kick off. So they're going to not only use local law enforcement, but they have already taken steps to deputize 600 Department of State employees to participate in these enforcement actions. And the 100-mile border zone enforcement, I will talk about that later, because that's relevant with respect to enforcement activity, not necessarily at work, but for your employees outside of work. Next slide, please. So what happens with an I-9 inspection? Well, an audit is going to be kicked off with a notice of inspection. An ICE officer will show up, present their badge, present you with a notice of inspection, ask that a copy be signed. They will let you retain a copy that's signed. They will tell you what the requirements are. They might even give you a nice little brochure that they carry with them at times about compliance with a notice of inspection. Then they will depart. Okay? Sometimes they might want to stay around, but in most cases they'll depart. These inspections can also be conducted in conjunction with a DOL investigation. So the officer might be a DOL officer instead of an ICE agent, as I told you about with the case, the individual with sequential green card numbers. And in that case, you're still going to have to comply, and you're going to have to comply within the required timeframes. So the I-9 notice of inspection will specify the information you need to produce for review. Typically, this includes a listing of all current and terminated employees in the past several years, copies of payroll registers, copies of quarterly tax statements, all I-9 forms that you're required to retain, employer tax information. It may ask for your corporate documents, okay? Your certificate of incorporation or a certificate of good standing with the state, okay? These are things that are typically asked for. Whether you've received any Social Security no-match letters, any communications from the Social Security Administration, okay? Now, they haven't been issuing those for a while, but it's possible employers would still have them. I have seen forms that have requested specifically a list of all contractors and all related 1099 forms, okay? That's not always on there, but if that's on there, that might suggest to you that there has been a tip of the employer to ICE, okay? The employer has 3 days to produce these documents, only 3 days. And if you don't produce them in 3 days, there can be significant financial penalties, okay? Now, it's possible that an attorney who knows the officers at ICE might be able to get an additional day or so without incurring penalties. But don't count on it, and know that you have to act quickly when you get a notice of inspection. Okay, next slide, please. So the ICE officer should introduce themselves and present their badge or identification when they show up. They all have a badge. They all like to show it. It's in those little flippy things that you see in the police procedurals on TV. And they will come in and they will show it to you and they will introduce themselves and tell you who they are. They will also have a business card. So ask for it. There's nothing wrong in doing so. Your staff should be trained to tell the agent to wait and then contact a supervisor or manager to meet with the officer. Okay? My concern is that if you don't do it in this process, it will get lost. You will not know about it. And several weeks later, you might get a visit from ICE, and it might not be a very pleasant. Okay? So that staff person at the front desk typically is not going to be a high-level employee. They should know to contact a supervisor or manager, and everyone should be trained to know what these are. The manager should review the inspection notice. And in most cases, the officer is only asking the company indicate receipt with a signature. Okay? And as I said, a copy will be provided of that. If the ICE officer asks to look around the premises, you should basically tell them no. They're not allowed to access non-public areas. They can walk around freely in public areas without a valid judicial warrant, but they can't enter any other premises. I have only encountered this a couple of times where the ICE officer has asked whether they can come in, and the staff member said, sure, have a look around. Not a good idea. And I've had it where they have been very aggressive about insisting that they had the right to come in to get the records. You don't want that. If they're going to go looking for the records, it's going to be through, immediately, it's going to be through a warrant. Okay. But I have had situations where they have aggressively tried to get the I-9 forms without a signed judicial warrant as part of an audit, and the employer has a mandatory 3-day period to present them. So that was an overstepping of bounds by ICE. Next slide, please. Okay, so once the officer leaves the premises, a record should be made of the interaction. Date, time, name of the officer, what was given to them, what was taken by them, and how long they were there. So you know exactly what the interaction was with the ICE officer. HR and senior management should be immediately notified of the service of a notice of inspection, and immediately steps should be taken to prepare for a timely delivery of the requested documentation. You should also immediately contact counsel for guidance in assisting you in responding to this ICE investigation. Or inspection, don't try to undertake it yourself. You're better off having somebody who knows what goes on in the context of these proceedings to be able to discuss things with an ICE agent or a forensic auditor, typically, who handles the review of the documents. There are a lot of potential defenses that you might waive if you don't take those steps. Okay. You may have I-9 forms that are ancient. You don't want to turn those over if they're not required to be maintained. So knowing what your rights are here, and also knowing what might be done in case there are some issues before production is important. If your I-9 forms are maintained electronically or they are maintained by a third party, then you should immediately take steps to ensure the records can be accessed and produced. That may require you to contact, if they're maintained on a remote server that's not under your control, you're going to have to contact whoever controls that server and be able to make sure you can get those documents to them in 3 days. And the reason I say that is that there was an enormous fine paid by a large retailer because they couldn't access their electronically stored documents in the time frame required in the notice. Okay? A lot of people are turning to electronic filing now, electronic signature pursuant to what's allowed under the M274 handbook for I-9 compliance. But you got to think about these steps. There are specific guidelines on the internet with USCIS telling you what factors you need to look for specifically with respect to electronic retention of Form I-9 records, okay? And one of the most critical aspects here is making sure they're accessible, okay? Can you get to them within the 3-day time frame and produce them? Okay, next slide, please. So what do we do next? Well, collect the requested records. You should have somebody review them to identify any potential issues. That can include review with counsel. Corrections are permissible prior to production, provided the corrections follow specific ICE guidance. This is in the M274 handbook. There is also a subsequent memo, Q&A, that gives some guidance on this that was issued by ICE, although whether that's going to be, it's fairly practical, okay? But it's also fairly step-by-step, so it's helpful. Much of that's been incorporated to what's on the M274 handbook, so that needs to be done, but do it with somebody who knows legally what some of the issues are, because you're going to confront issues like annotating when the change was made. Okay, I never say, if a date's missing, don't just add the date and add an annotation as to when it was corrected. Missing I-9 forms can also be completed prior to production. That's not necessarily going to reduce your fines, but it has been useful in some cases. I had one case where the employer had 10 employees, none of them had I-9 forms, they were all US citizens. The reason they didn't do the I-9 forms is they didn't think they had to, because they only employed citizens because of government contracts. That said, they completed them all, handed them in within 3 days, and we got a compliance letter. So that may not happen now, but it happened in this particular case. Never, ever, ever backdate anything, ever, okay? You're gonna go to jail if you do that. Always consult with counsel before any changes are made. And remembering that failure to comply with the guidance or backdating records could result in criminal charges. You don't want to be there. Next slide, please. What happens after the inspection? Well, you can get a number of documents. You can get a list of individuals with suspect documents. You are required to act on this list. There is a specific process to go through. Calling in the employee, telling them they're on the suspect document list, giving them a new I-9 form with the list of documents and telling them, here's the list of documents. You need to provide us with something because these documents are suspect. Sometimes you get into difficult conversations with the employee and they'll tell you they're undocumented. And then there's steps that we have to do at that point. Generally, you have 90 days to resolve those issues, although the guidance is unclear. And to be honest, this is actually an area where I have been able to work with forensic auditors to assist the client in getting additional time to work out these problems so that it doesn't impact business operations. Whether they're going to be so compliant now is hard to tell. Different ICE offices have different procedures, so knowing the local office can be helpful as well. You might get a technical corrections letter as well, where there may be a bunch of small mistakes on the forms, like missing date. They can be corrected very simply, and you'll get a letter asking you to do so. And if you don't do it in the time frame, it can be a violation. And after ICE has completed your review, you might get a compliance letter, which means everything is hunky-dory. You might get a warning notice, meaning it wasn't hunky-dory, but we managed to correct some things, so better luck next time. Or you might get a notice of intent to fine. Okay, next slide, please. So what are the penalties for an I-9 violation? Well, fines for incorrect or missing forms can range from $281 to $2,789 per violation. And I'm talking per violation, and there can be many violations per form. And there's a matrix that they use to determine whether it's 281 or 2789, depending on the number of employees and the number of forms that have problems and the number of unauthorized workers. And that can shift you from 281 up to 1,000 or 2,789 very quickly. And then that number is multiplied by the number of errors. So if you have, like I said earlier, I had a situation with a small workforce. They had a number of unauthorized workers and they had a number of form problems. Even though they had probably, 20 workers, fewer than 20 workers, the potential fine was in excess of $140,000. Okay. Knowingly hiring unauthorized workers can give you equally high fines. On a third or more offense, it can be up to $27,894 per unauthorized worker. Okay. There are mitigation factors, but it's a 5% reduction for each of the mitigation factors, and it's often difficult to even get 25% reduction. And even when you're talking about a huge number, in a fine, 25% isn't going to be great, particularly if you're a small employer and the potential fine is over $100,000. It's a lot of money. And those are size of the company, good faith, seriousness of the violation, presence of unauthorized alien, and a history of prior I-9 violations. Now, I have been able to negotiate much lower amounts, but that only comes about through the attorneys when it's been referred to the Office of Special Counsel to pursue the case. And at that point in time, you can have more serious settlement discussions. The forensic auditor really can't do much more than the 25%, except in some very exceptional circumstances. And lastly, for federal contractors, a significant I-9 violations can result in debarment from federal contracts. Next slide, please. So what are some best practices? I'm going to run through these because I have a lot more I want to cover. And time, we've got about 20 minutes left. Have 1 or 2 trained employees who handle all of the I-9 verifications. All remote verifications should be conducted by an agent. Download and read the I-9 handbook. Develop a process to double check and confirm the forms are completed within 3 days of hire. Have a secondary review. Keep separate from personnel files. Absolutely imperative, because if they come in and they they want to go for the I-9 forms and they're in the personnel files, they're going to take your personnel files. No one's going to sit down and go through them and just take them out page by page from personnel files. Develop an annual audit plan to review and correct. Properly re-verify all expiring EADs, create a notification system for that, and discard unneeded I-9s from terminated employees. And if you're truly concerned and you're not in a state where there is E-Verify requirement, consider enrolling in E-Verify. Okay? Next slide, please. So worksite enforcement activity. Okay? Develop a plan of action for staff in the event ICE or local police show up and request access to the premises for purposes of worksite enforcement activity. Okay? Knowing that it could happen, even if it never does, could be sufficient reason to outline a plan of how staff need to respond, much like you're going to do with an I-9 audit, which is probably more likely. Okay? Knowing what the steps are and having staff know what that plan of action is. I've even seen some who have very simple flow charts saying, if this person shows up and gives you this is where you go. And it's a flow chart to the next thing, okay? Knowing that plan, practicing it, and being comfortable with it is going to make it seem very natural and smooth and allow staff to remain calm and follow the plan, okay? There is no penalty for staff when they are given a warrant, a subpoena, a notice of inspection to say, can you hold on a minute, please? I need to contact my supervisor or manager. Okay? That may be all that they do under the plan, but they still need to be able to do that. Okay? And it's easier if they understand what's coming down the road. If the officer requests access to non-public areas, a judicial warrant is required, and staff should know to ask for a warrant, and they should be comfortable asking for a warrant. They come in and say, we're coming in there, going to go in there in the back room, and we're going to go and arrest, John Smith. You don't want a staff sitting there going, what do I do? It would be, well, thank you very much, but that's a private area. It's not accessible to anyone who's in the public. Do you have a warrant? So they should be comfortable doing this. Next slide, please. This slide just gives you an identification of what is an ICE warrant versus a judicial warrant. Okay? Now, they might look a little different, but an ICE warrant is issued by a court, and it's not signed by a judge. It might authorize the detention and arrest of an individual, but it is not sufficient to grant access to private property. You need a judicial warrant signed by a judge. And you can see the difference if you can look at the screen. I apologize for it's teeny tiny, but you can see the difference in the two. Okay, so next slide, please. So handling a warrant. Like I said, administrative warrants signed by an immigration officer are do not authorize that individual to enter non-public areas. The staff should be trained to look at the warrant. Is it signed by a judge? What type of warrant is it? And is it still valid? It'll have a validity date on it. Staff should ask for officer's name, badge number, and contact information, and then tell them they'll contact a supervisor or legal counsel for further guidance. Nothing should be provided without a warrant or subpoena and advice from legal counsel. Once this gets elevated to management, management will know to contact legal counsel. Legal counsel will give you advice as to how to comply. It may ask for specific documentation, or it may grant access to conduct an arrest of a specific individual or individuals. We don't know until we see the subpoena or the warrant. And then that'll determine what the response should be. Okay, next slide, please. Other steps to take in the event of an enforcement action. Staff should be comfortable telling immigration agents they cannot enter non-public areas without a warrant. They should ask for the warrant. They should consult with their supervisor. And they should be able to say that there is an organization policy to deny access to non-public areas of the facility without a warrant. Now, they can be in public areas, and if there are persons in public areas who are staff members, they can approach them and they can talk to them. Okay, we'll get to that in a minute in terms of know your rights materials, but staff should never tell anyone that they should not speak to an officer. Okay, they can tell people what their rights are, but be careful about yelling it out. You have the right to remain silent. Okay, when they're actually talking to them. Okay, because that might be misinterpreted. But staff should know that, not to interfere, but also all the staff, particularly those who might have a reason to be concerned, should know their rights. I mean, keep in mind, that doesn't mean that you have unauthorized workers in your work site. You might have workers who are perfectly lawfully authorized to work under TPS programs, under DACA, under asylum, whatever. They may have committed a misdemeanor infraction. They might have gotten arrested for DUI. Okay? These things happen to everybody in some way, shape, or form. They may get detained at a traffic stop and given a violation of some kind. Okay? That might be the basis for why ICE is showing up. Okay? We don't know. Maybe they'd gotten a domestic spat and somebody filed for a protective order of some kind and there were allegations of abuse. We don't know. So having your staff know what their rights are, because everybody to some extent probably has somebody who is an immigrant or in some form of status in their workforce. You may not know immediately who it is, but they might be there. HR might have that documentation and know who it is, okay? But you need to be mindful of that, okay? Next slide, please. Never lie to an immigration officer. They might be plainclothes, so you always ask for their badge and name. Once they've departed, a complete report of the visit and questions asked should be made. Never take any steps to conceal any person or aid in their escape from the premises. Taking steps to do so can result in accusations of harboring, and we don't want to go there, okay? So staff understanding what they can and can't do is very important, okay? And knowing what potential risks are out there are important. They might get scared just if you tell them that, which is why training is important. Okay, they have the right to observe a detention or arrest from a reasonable distance so as not to interfere. They can also videotape it from a reasonable distance, provided they're not interfering, although in some states there has been attempts to proscribe that right. So again, talk to counsel. Next slide, please. Some additional protective steps: develop that plan that I've talked about, identify a call tree for staff, train employees in each step, minimize public space, mark private areas clearly, train the staff on harboring and related immigration crimes, and develop policies on data collection and privacy, particularly with regard to personal protected information and health information of employees. ICE and or local police may want to seize records, and there may be a reason to want to protect those types of records absent a warrant, okay? And again, maintain your I-9 forms separate from all other files. Next slide, please. So, know your rights. This is the last point of the presentation. I apologize for going long, but I'm going to cover this rather quickly in case there are any questions. And specifically, this is more for both for the company and management, but also for you to be able to communicate to employees. It doesn't mean you have to call in anybody, but you can make materials available to them. And these are available from the ACLU. They're available from the National Immigration Law Center. They're available from, say, a variety of charities that assist immigrants and refugees. So these resources are out there. If you need them, you can contact me. I'll assist you in getting you to the links that have them. I have not pasted them here on the presentation because it's more of a whiteboard presentation. But they are out there, and employees are going to come to you with questions because they'll be concerned. And the information that's in these forms is what you can provide to them, okay? Now, one additional concern is that, you know, the Constitution protects persons from random and arbitrary stops and searches. The government has taken a position that this doesn't apply at our borders, which may justify routine searches without a warrant, but reasonable suspicion within a 100-mile perimeter. And if you look at that 100-mile perimeter, virtually all of the state of Maryland and a huge portion of the US is covered by that 100-mile perimeter, okay? Border Patrol can't pull someone over or conduct a search without reasonable suspicion, which means it must be more than a hunch, okay? That doesn't mean that local police and DHS or ICE are going to comply with these requirements. They might violate them. So having employees who might have concerns about being picked up, maybe they got an arrest or charge filed against them of some kind, they should know their rights and know that potentially there might be some constitutional rights they can assert here, particularly if they get their own counsel and they know the circumstances and they know how to act in the circumstances. Next slide, please. Employees have the right to remain silent or tell an agent they will only answer questions in the presence of an attorney. An immigration officer generally cannot detain an employee without reasonable suspicion or an arrest warrant, and they cannot search belongings without probable cause or consent. Employees have the right to say no. Okay? Silence does not meet any of these above standards. Okay, next slide, please. If an employee has valid immigration documents and are over the age of 18, the law requires that they carry these documents and produce them if asked. This includes TPS, non-immigrant visas, and green cards. And declining to produce the documents in such a situation could present legal problems for that individual. Not everyone complies with this. Not everyone's carrying around their documentation at all times. Many people do, okay? And if asked, they shouldn't be concerned about presenting it to an immigration officer, particularly if they're lawfully present or authorized to be present in the United States. Never provide false documentation or information to an immigration officer. If they have entered the United States without inspection or otherwise have status, they could be subject to expedited removal. And that's certainly going to increase in this administration. Again, non-citizens, your employees who are not citizens of the United States should be mindful of all traffic laws, shouldn't risk driving after consuming alcohol, and just avoid any potential circumstance that might legitimate a traffic stop or get them into a criminal proceeding, which could result in them being arrested at work or outside of work. Okay. Next slide, please. So, other steps concerned employees may take. You might have employees who are in a status such as TPS, or they've got papers filed which lawfully allow them to work, but they may not necessarily be able to travel without, say, a parole document. And that might apply to people in DACA status as well. There could be significant issues with them being able to return to the country. So the advice you might want to say to them is maybe you don't travel and maybe you talk to your counsel before you leave the United States, because they may not be able to come back as an employee. Knowing your status, is it going to expire soon? Is my work authorization going to expire soon? Apply to renew it. If you can do it, apply for it, because it might take a long time to adjudicate it. The know your rights I mentioned earlier, and that is employees should have access to these forms. It doesn't mean you have to ask anybody their status. It means you have to go around handing them out, but you can make that material accessible to employees, because, like I said, you will have employees who might be in one type of protected status, and they might have concerns. And they'll come to you and ask you questions. Again, other advice you can give to them, tell them to have a family safety plan. There's some steps you can take for guardianship that might protect a family in case somebody is detained. They should take steps to protect their digital and physical safety as well. You know, what's their footprint online? Do they need that footprint online, and so on? And then again, take steps ahead of time to protect family assets and custody of children in the event of detention. Now, there are law firms, pro bono law firms out there, legal aid services, Catholic Charities, a number of others who can provide guidance and advice in these areas for staff who have concern. And you can certainly refer them to that so that they get the guidance that they need. And I mention these as issues for you just so that you're aware of them and know that these are potential concerns that are going to come to your attention. So with that, that is the end of the presentation. We're very close to the end in time. I don't see that there are any questions. So I'm going to thank everybody for listening. If you do have additional questions, please feel free to reach out. I'm happy to answer any questions you have. I know it's a lot of information to digest, but the overall message ought to be put together plans for how you're going to address each of these situations and get staff trained, knowing the points that I covered here and knowing where potential problems can arise and what you can do about it. So thank you again. At that point, I'll end the presentation. Thank you.
Thank you, Peter, and thank you everyone for attending today's webinar. Reminder that you will receive a follow-up email within 24 to 48 hours with a link to view a recording of today's webinar, as well as a copy of the slides. On behalf of Whiteford and our presenter, thank you for joining us and have a great rest of your day.